Let's hold on and let everybody else get this out, and the other council get up here. So.
That's a lot of time to talk.
There's no penalty for not talking that long.
Good.
All right, I think we're ready to proceed. You may proceed.
May it please the court. Robert Sirianni, appearing on behalf of Mr. Holley as the appellant. Mr. Holley is seeking a reversal of the Court of Appeals opinion. And in this case, the Court of Appeals dismissed his criminal appeal of a sentencing matter because he did not include a guilty plea transcript in the court record on appeal. Mr. Holley contends that the Court of Appeals got the matter wrong by citing the Miller case, which was a per se dismissal of the appeal because of a lack of a guilty plea transcript. And we believe the Cottle case, which was a 2012 case, controls the matter. And under Cottle, the Court of Appeals should have issued a case-by-case decision if a plea transcript was necessary to determine the outcome of the sentencing issues. In this case, the appeals court followed Miller, which we believe was incorrect, and the proper approach would be under the Cottle analysis. And a per se dismissal of the appeal for lack of a plea transcript was not proper. The Court of Appeals said that because the plea transcript was not included, that the matter could not be determined whether or not Mr. Holley received an unlawful sentence, and they cannot ascertain whether or not the sentence was over the guidelines or under the guidelines, or if the trial court issued a correct opinion in the case. Under the Cottle decision, we believe that the Court of Appeals should have taken the approach of examining the case-by-case analysis to determine if a meaningful review was appropriate. In our case, we actually had plenty of documentation where the court could have determined that if the sentence was unfair or unlawful. For example, we had the indictment in the record on appeal. There was a PSR and an amended PSR. In addition, there was a plea form and a judgment, and also the sentencing transcript. Also noted is that the Court of Appeals in the case had a discrepancy. The Court of Appeals talks about a range 1 versus range 2 punishment. In the case below, the trial court judge punished Mr. Holley under a range 2. The Court of Appeals noted that and said that Mr. Holley is actually a range 1 because he's 8 to 12 years, had an 8 to 12 year sentence, and a range 2 is a 12 to 15 year sentence or 12 and above. Therefore, the Court of Appeals had plenty of information to determine whether or not the sentence was unlawful. With respect to the second argument.
Well,
yeah.
go ahead. No, go for it.
So I'm just wondering if you could explain. So are you familiar with our decision in Hoover versus State?
That's not on the brief, Judge. No, I'm not.
Okay. Let me just read you a snippet from that.
Yeah.
Okay. So a plea bargain sentence is legal as long as it does not exceed the maximum punishment authorized for the plea offense. And a knowing and voluntary guilty plea waives any irregularity as to offender classification or release eligibility. And so I'm wondering if you could address, in light of that law, that precedent,
yes.
yeah, why are there any sentences, I guess, that are illegal in light of that precedent?
Well, the sentence is not. We never contended the sentence was illegal. We contended that the sentence was, the enhancement part of the sentence was illegal. That part was illegal.
Well, but that's what the court was concerned with.
Right.
And that was why, I guess this discrepancy in offender classification, right, was what prompted
Yes.
the dismissal.
Well, that was one of them, the offender classification between range 1 and range 2, but also the implication of the out-of-state convictions from Georgia that were used to enhance Mr. Holley's sentence, because the trial court in the sentencing document applied out-of-state cases to increase Mr. Holley's sentence. Rather than, he could have got probation, in other words. He could have been classified as something completely different. But the court used these out-of-state convictions that were improperly applied in order to enhance his sentence.
Is that the sentence itself or the manner of service?
I apologize, Judge. Is the sentence itself, or what was the question?
I'm sorry. As Justice Campbell pointed out, a guilty plea is a guilty plea. Right. Mr. Holley got 9 years. Are you are you alleging that the 9-year sentence is somehow illegal? Or is it the manner of service? Is it the fact that he didn't get probation or some alternative sentencing?
You're right, Judge, the second part, he didn't get probation or lower sentence. I'm not saying the 9 years.
Different cat, though, right? You've got the sentence. So is the 9-year sentence, are you challenging the 9-year sentence?
You're not challenging the length of the sentence.
Judge.
You're just arguing it should have been probation.
In
or
the
at
manner,
least part
yes,
of it.
we're challenging the manner in which it was the result.
Okay.
We're not challenging the 9-year sentence because he agreed to a 9-year sentence.
Yeah, that's what we thought, too.
Yeah,
You're
that's the
correct.
reason the Hoover case controls in that situation, because
Yeah.
he agreed to it. It's within the range.
He agreed to, yes, Judge, but he agreed to a 9-year sentence, but he believed that he could have gotten qualified for probation. And what the court did was they applied one incorrect category on him. They said he was guilty of possession of a firearm and the commission of a dangerous felony, which is a wholly different statute. And he wasn't charged with that. And that statute actually carries a mandatory minimum of 3 years. So the court used a completely uncharged crime against him.
Well, but isn't it logical to think the court simply made a misstatement in saying enhancement in its use of that? It really wasn't an enhancement. It was consideration of whether alternative sentencing was appropriate. Those are two different things.
You're right, Your Honor, but the state of Tennessee did file a subsection 202 notice of intent to enhance the sentence. And the way the trial transcript reads is that the court used that offense plus the out-of-state convictions to not give him probation, to not give Mr. Holley probation.
If I could interject here, so that was one consideration. Let's assume that that was one consideration. And even if we assume that that was an error, aren't we required to apply a harmless error analysis when we review that? I mean, that wasn't the only consideration that on which the trial court relied in declining to grant probation, right? There were other
Yes.
things like previous probation violations, right? Or was it parole violations? In any event, that was not the sole reason why probation was denied. And don't we have to look at kind of the decision as a whole, and even if that was error, apply a harmless error analysis to determine whether that would require reversal?
Yes, Judge. Well, I'm not asking this court to re-sentence Mr. Holley. What I'm asking the court to do is reverse the Court of Appeals decision on the issue of whether or not a guilty plea transcript was mandatory for the Court of Appeals to make a decision on his case.
Well, which would then require us it would be likely then the better course would be to remand it to the Court of Criminal Appeals.
Yes. Yes, Judge. I don't want to go into the merits of whether or not he was properly sentenced. It doesn't really matter for today's purposes. What I'd like the court to do is two things. One, I'd like the court to issue an opinion saying that the reliance on Miller was improper, the 1987 case in Miller, and that the court should have used a case-by-case analysis under Cottle, which there was meaningful review present, and therefore the Court of Appeals should be reversed. I'd also like the court to add one more sentence in there. Under the Bristol case, there was an oral argument occurred before this court, and the court sua sponte supplemented the record on appeal for another transcript. I think this court today could actually sua sponte under Bristol, supplement the record with the guilty plea transcript, send that to the Court of Appeals, and let them make the decision.
Well, let me probe that a minute, though.
Sure.
How is the guilty plea transcript pertinent to the actual issues that you appealed? Does it,
Well-
how would it?
You mean to the Court of Appeals or to this court?
Well, it's a Court of Criminal Appeals. We
Yeah,
have a separate
yeah,
Court of
yeah.
Appeals and
Sorry,
a
Court of
Court of
Criminal
Criminal Appeals.
Yeah. How is the transcript of the guilty plea proceeding pertinent to the issues that you appealed, apart from the
Right.
the issue with Range 1 versus Range 2 that the Court of Criminal Appeals talked about?
Yes, Judge. Well, we don't believe the guilty plea transcript is necessary, but the Court of Criminal Appeals, did believe it was necessary. Because the Court of Criminal Appeals dismissed the entire case because there was no guilty plea transcript, and they believe that we didn't satisfy our duty under Rule 24 to,
Well, you know the issues that you appealed.
Yes, Judge.
I'm
Yes,
asking,
Justice.
your judgment, is the guilty plea transcript necessary? Is it?
No.
Okay.
It's not necessary, but in order to appease the Court of Criminal Appeals, like I said, this court under Bristol could also, in an opinion, issue an order sua sponte, supplementing the record with the guilty plea transcript, send that to the Court of Appeals.
Right,
Along
but-
with an order saying that the Miller case was improperly used.
Right. You're saying that on the issues that you appealed, the guilty plea transcript is not going to be
It's irrelevant.
eliminating? Okay.
It's absolutely irrelevant, but the Court of Criminal Appeals believes that it is relevant. That's why they dismissed the case.
Well, they believed it was relevant as to a completely different issue that you did not raise.
They
Right.
sort of threw in that it was relevant to your first issue, but
Yes.
I didn't see an explanation of how it was relevant, which is why I was asking you, because I couldn't figure out why
No.
it would be helpful to resolve the actual issues that you appealed.
No, it would not, like I said, it would not be helpful to resolve the issues that I briefed at the Court of Criminal Appeals at all.
You just want to appease them, get on with it?
Yes, yeah. Well, like I said, I believe that this court can issue an opinion citing Cottle, saying the reliance on Miller was improper, and that under Bristol, this court could sua sponte, supplement the record before the Court of Criminal Appeals with the guilty plea transcript.
Okay.
And like I said, let them make the decision whether or not his sentence is proper. Let them make the decision if his sentence was enhanced. Let them make the decision if he should have had probation or not probation. I don't think this court needs to even go into those issues, whether or not the sentence was accurate. I think that this court needs to be only concerned whether or not the reliance upon Miller was proper. And before I conclude with maybe a few minutes for rebuttal, I know I didn't ask Justice Bivens in the beginning whether or not I should have rebuttal time, but I'd like a few minutes for rebuttal if possible. We did brief one second issue on the case, and that concerned the use of the enhancement. And there's one part of this issue that I think actually is important. The trial court used the out-of-state convictions to, whether or not you want to believe it enhanced or didn't give him probation, Mr. Holley probation, whatever it is. The point is the state sought an enhancement under subsection 114, but under subsection 202, the state of Tennessee must have a certified copy of the prior judgments and convictions from other states in order to enhance Mr. Holley's sentence, and they did not provide that.
Why
Well,
is
well-
that not waived? I'm sorry.
Yeah, no, you're going right where I was, yeah.
I apologize.
Why is that issue not waived? Well, that's my first question. The
Yeah.
second question
Yeah.
is, you've said multiple times you only want us to send it back to the CCA, but you've raised this enhancement issue in your brief, and you,
Right.
so,
Well, yeah, I did, well, we did raise it before the Court of Criminal Appeals. I think that my point is that, again, I don't need this court to decide whether or not the enhancements were proper, but what needed is an opinion to the Court of Criminal Appeals, hey, you might want to take a look at this enhancement issue as well, because it was briefed before
I
them.
guess go back to my first question. Why the pre-sentencing report, why is that issue not waived?
Well, oh, I see, because trial counsel didn't object to it? Is that why?
Yes.
Yeah.
Yes, yeah, you're right, yeah, yeah. I mean, well, trial counsel did not object to the out-of-state convictions that the trial court used to qualify the sentence. That is correct. So
So how is that not waived?
I'm going to argue fundamental error, so that it was preserved by us on a direct appeal by fundamental error. And the statute's pretty clear, you do have to have a certified copy. The
Do you mean plain error under Tennessee law? Is that what you're
plain error,
talking
yes,
about?
Yes, Judge. Thank you, Judge. Justice.
But you haven't made a plain error argument in your brief, did you?
No, we did not, no. No, we did not. But that only concerns again, the second issue. I think the first issue could, reversal to the Court of Criminal Appeals could decide the matter. And with that, I'd like to reserve the rest of my time for rebuttal if there's no other questions. Thank you.
All right. Okay. And you don't have to use it all, Mr. Shan.
Good afternoon. May it please the court, counsel. My name is Will Lundy, and I represent the state of Tennessee in this appeal. This court asked the parties to address 3 issues in this case. First, this court asked the parties to address whether Holley's failure to provide a transcript of the guilty plea hearing in the appellate record rendered the record inadequate for the Court of Criminal Appeals to conduct meaningful appellate review. The state's position is that when the Court of Criminal Appeals found that the record was inadequate, it did so reasonably, and a lot of that is based on the issues that Mr. Holley raised at the Court of Criminal Appeals. Many of the issues that he raised depended upon the factual basis of his plea, and specifically whether or not he possessed the gun that he was convicted of having possessed, and whether or not he had an intent to sell the marijuana that he was also convicted of having
But doesn't
possessed.
Hoover control the waiver of those?
I'm sorry,
And
Justice
it
Bivens, I
doesn't
didn't hear you.
Hoover control the fact that those claims are waived in this situation? And if they're waived, how is the transcript relevant at all to the issues that should be before the Court of Criminal Appeals?
Based on what Justice Campbell read about Hooper and waiver, I mean, absolutely a defendant waives irregularities with the, with his sentencing range and those kinds of things. The problem with this case is just the inconsistencies within the record as to what the defendant actually pled to. We don't have the full record of his. Of his actual plea. We don't have the factual basis.
Sorry, go ahead.
Go ahead.
Did trial court not recite much of that at the sentencing? And then if we don't have a transcript, why would we not presume that to be correct?
As far as the sentencing range, the trial court just as a general matter said, well, I'm going to sentence under range 2. And when we look at the plea agreement itself, it doesn't say range 1, it doesn't say range 2. What it says is, particularly for this Class B felony that ultimately gets him this 9-year sentence, it says, it gives the range, I believe it was 8 to 12 years, which is a range 1 sentence. So really the question that the Court of Criminal Appeals was trying to figure out is, okay, did he agree to a sentence that was illegal, which would result in waiver, or is this a clerical error that we can just correct, on the record?
Well, there were, as I understand it, there were 2 issues regarding specific counts in that. It was count
Yes.
5 and count 8.
Yes.
Under count 5, if I remember correctly, it was still a B felony.
Yes.
And so the 9-year sentence would be legal. The only question was with regard to the other count, which was an E felony, where a 9-year sentence would be illegal, but couldn't that easily have been a clerical error on the part of the trial court that they could remand?
It certainly could have.
That the Court of Criminal Appeals, time after time, will remand back for a correction of a clerical error.
It certainly could have been, and I think with the transcript of the plea hearing, we would have known that a lot more certainly, or at least we could have.
But if that issue wasn't raised, why is the transcript necessary?
Again, the transcript, as far as with regard to that issue, I don't think the transcript really is necessary because the defendant didn't raise it. And if the defendant, is concerned that his sentence may be illegal, he can raise it on a Rule 36.1 motion at any time.
If it's not relevant, then why shouldn't we reverse this case and send it back to the Court of Criminal Appeals to review this case on the merits?
If the court disagrees, if the court concludes that the Court of Criminal Appeals wrongly dismissed the case, then this court is in just as good a position as the Court of Criminal Appeals to look at, to look at the record that we do have, presume that the missing transcript would support the trial court's decisions, and then, and then review under the standard of review from Bice and Caudle and all of those cases, all of its progeny. And in that case, I would ask this court simply to affirm the trial court, because what the trial court did here was almost a model of how courts should conduct sentencing hearings. There are,
Let me go back, though, to follow up on
Sure.
Chief Justice Bivens' question. On the actual, so the Court of Criminal Appeals said that the guilty plea transcript was relevant to the issue that it raised, problems with the judgment, And also with the first issue that the defendant raised, whether the trial court erred in considering the uncharged offense, do you say that the guilty plea transcript is essential for the Court of Criminal Appeals to review that issue?
The guilty plea transcript would have had the factual basis for the defendant's pleas, and his arguments were predicated upon, what he was arguing is that the evidence that, or perhaps that the factual basis wasn't adequate to support what the court said.
Wouldn't the Court of Criminal Appeals be able to say, we will review this issue based on the information that the defendant has given us, and we will presume under Caudle that if he did not provide the transcript of the guilty plea hearing, it must support the trial court's actions?
Yes, the Court of Criminal Appeals could have done that here.
Well, and furthermore, if we're talking about the plea colloquy, do we really think the plea colloquy is going to include discussion of the uncharged offense? That comes later from the sentencing aspect and is probably in the pre-sentence report. I did hundreds of pleas as a trial court judge, and I can't recall any in which during the factual recitation that there was discussion of an uncharged offense.
Right. I think what the trial court was doing at sentencing was it was looking at, okay, the defendant has pled guilty to, on the one hand,
I'm not talking about the trial. I'm not talking about the trial court. We're still focusing on whether the transcript is necessary to the CCA. If the transcript is going to, if we're talking about the factual basis for the plea, that's not going to help at all with regard to an uncharged offense, right?
I mean, as far as the, as far as the defendant's arguments were concerned, he's arguing that that the evidence didn't support the fact that he possessed the gun. He's arguing that it didn't support the idea that he actually, had the intent to sell this marijuana based on the amounts. And so those kinds of things would hopefully have been included in the factual basis for his plea, and it might have been relevant there.
Here we have the defendant's lawyer who is urging this issue, that the trial judge should not have considered the uncharged offense. He says, no, the transcript would not have been helpful. So I get back to my original question. Do you agree that the guilty plea transcript was not essential for the Court of Criminal Appeals to consider the actual issues raised by the defendant?
Given the actual issues that were raised by the defendant, I think the answer has to be no, that transcript is ultimately not really necessary. And that's particularly true because we're here under Bice, we're here under Caudle. What we're really reviewing is the sentencing court's, overall decision. Did the sentencing court,
but yet the CCA followed Miller instead of Caudle.
The CCA cited Miller. It also cited Caudle. Whether it followed one or the other is up for debate.
But Caudle never says that dismissal is a remedy, correct?
That's true. Caudle does not say dismissal as a remedy. That's correct. And I would point to the state's brief where we spoke about Rule 26 being a potential remedy. I would point the court to Rule 3E of the Rules of Appellate Procedure that also provides dismissal as a remedy in certain circumstances. So I mean, it's not as though the Court of Criminal Appeals has no power to dismiss a case. The question is really, did it abuse its discretion when it dismissed this case? And so,
Mr. Lundy, if I want to go back to, I guess, the issues that the Court of Criminal Appeals thought it needed the guilty plea transcript to address. So, this offender classification discrepancy. The defendant did not raise any issues with respect to that before the CCA. We have said, however, that when you're dealing with an illegal sentence, that a court lacks jurisdiction to impose an illegal sentence. So presumably an argument regarding the illegality of a sentence, a sentence that exceeds the statutory maximum, for example, would be the sort of thing that could be addressed and arguably should be addressed even if the defendant doesn't raise it. And so with that context, I want to talk about count 8. So, count 8, this Class C felony, the statutory maximum for that Class C felony, my understanding is 6 years. Is that right? Or is it?
I think it was 2 to 4, actually,
Well,
for
on
range
that,
2. And I
depending
could
on the
be
offender classification.
Yeah, right,
I
yes.
think. But in any event,
Oh, right, I see what you're saying,
the
yes.
sentence that was imposed for that Class E felony exceeded the statutory maximum.
Yes, that's correct.
So is that an issue that, I guess, the CCA could have even was obligated to address, even if the defendant hadn't raised that issue?
Because it's jurisdictional, that's a great question. When I look at Rule 36 and the court, which is what the Court of Criminal Appeals relied on, that's more of a discretionary task. But as far as
Yeah, I don't think I don't think the CCA really framed the issue in those terms. I mean, it was really concerned more with this offender classification issue, but even resolving that discrepancy wouldn't render the sentence that was imposed, or at least that's reflected on the judgment form, a legal sentence because it exceeded the statutory maximum.
That's right.
So what are you going to do if that's the case? The CCA raised that issue. Let's assume that it's something that does need to be sussed out. Wouldn't the appropriate thing to do be to decide the issues actually raised by the defendant, remand back to the trial court to correct that? Under no set of circumstances does dismissing the appeal address that issue, does it?
No, it doesn't, that's correct.
And the sentences were run concurrently, correct?
Yes.
So there's no way there's any harm here.
Right.
I mean, you
That's
would
also
have
true.
to, you would have to amend the judgment.
Right,
or,
it would be
you
an
know,
amendment
like
of the
that-
judgment
right,
form.
on
That
that
was a
count, but it
clerical
wouldn't
mistake.
affect, yeah, but it wouldn't
Right.
affect the sentence.
Yes, absolutely, that's correct.
So General Lundy, let me just jump in here and just maybe try to ask a common sense question here.
Sure.
Both you guys have said that the transcript's not relevant to the issues raised on appeal. The Court of Criminal Appeals dismisses the appeal for failure to include an irrelevant transcript. What would the state have us do? I want to make sure I understand what your position is. What
Right.
would the state have us do here?
Right, and so in the brief, I of course, argued 2 different positions, trying to defend what the Court of Criminal Appeals did with regard to the dismissal. In the alternative, I would ask the court to do what the Court of Criminal Appeals, what I'm understanding this court to have, understood the court should have done, and that is to review the record and review the defendant's arguments with the presumption that the missing transcript would support the trial court's sentencing decision, at least with regard to the manner of service, which is ultimately the issue here. And in that case, again, based on the trial court's sentencing decision, which was very thorough, the trial court found all of the factors that come from Tennessee statute, so section 4035-103, and it found all of the Trent factors. It considered all of those things, and it ultimately concluded, based on the defendant's criminal history and based on his other failures on probation, I believe you mentioned, Justice Campbell, that the defendant should serve this sentence in confinement. And the state's position is that this court should affirm that sentence. With regard to the judgment form, I think a remand to correct the judgment form on count 8 in particular, since that, as you pointed out, is an illegal sentence under any analysis, to remand that, to have the trial court remand that or correct that would be eminently appropriate.
Mr. Lundy, why should we address the merits in the first instance instead of just correcting the CCA's dismissal for failure to provide the transcript, and then directing the CCA on remand to address the merits of the issues that were actually raised and the count 8 issue?
And I think the answer to that, Your Honor, is just in the interest of judicial economy. I mean, this court has done that in the past. And, when we look at, this court has the same record that the Court of Criminal Appeals had. The trial court's order, or the trial court's, recitation of why he ordered the defendant to serve his sentence in confinement. I mean, it is what it is. This court has that transcript. It's a very thorough, very, very thorough order, and so, I mean, this court's is the same position that the Court of Criminal Appeals would be in, and so I just think in the interest of judicial economy, there's no reason to remand to the Court of Criminal Appeals. I mean, and to be fair, if you wanted to remand to the Court of Criminal Appeals apart from judicial economy, they would have the same, it would be their task to look at Bice and to look at Caudle, to look at under that standard of review and presume that this missing transcript supports the trial court's order. And I think in that circumstance, there's simply no question that what the trial court did here was not an abuse of discretion. It didn't wholly depart from the Sentencing Act. Again, this court is in just as good a position as the Court of Criminal Appeals to do that.
Well, plus, the defendant raised 2 other issues, and those were not even hardly alluded to, so.
In the Court of Criminal Appeals, Your Honor?
Yes.
Yeah, and obviously I briefed the issues in the Court of Criminal Appeals. I would just point out that in the Court of Criminal Appeals, the defendant didn't cite to Bice, he didn't cite to Caudle. In fact, all of his arguments were predicated upon the application of the 1989 Sentencing Act prior to the 2005 Sentencing Act. I mean, essentially, he was asking for relief that to which he wasn't entitled. He didn't ask the Court of Criminal Appeals to review under the abuse of discretion standard that this court articulated in Bice and Caudle, and so those issues ultimately would, in the end, would be waived, and I argued waiver in my brief below. Does the court have any further questions for me? I think
we're good,
okay.
Mr. Lundy.
If the court has no further questions for me, I'm prepared to cede the remainder of my time. I would simply ask this court, I would ask the court, the state's position is we're asking the court to affirm the Court of Criminal Appeals, but in the event that the court decides not to do that, to reverse, I would ask this court to affirm the trial court, as I have argued, and remand for a correction on that judgment form. Thank you.
Thank you, Mr. Lundy. All right, Mr. Sirianni.
Your Honors, I have no rebuttal at all. I like where the court's going. If there's any questions, I'll be happy to entertain them. But like I said, the only thing I would say is that remand with instructions that Miller was wrong, use Caudle, and if the court's so inclined to say that they can sua sponte supplement the record on appeal with a guilty plea transcript under Bristol. Thank you, Your Honors.
Thank you.
Judge, I apologize, Justice, I apologize about the misterminology. I practice in like 12 states. Sometimes I forget where I am, but I do love Tennessee, so thank you.
All right. Thank you, counsel. That concludes our docket here today. Mr. Clark, please adjourn.
All rise.